Bar Rules Series. Torts.
Intentional torts. Intent. Intent is established when the defendant acts with the desire or purpose to achieve an outcome, or with knowledge to a substantial certainty that the outcome will result. Transferred intent. Transferred intent is a substitute for intent when the defendant has the necessary intent against one person but instead commits a different tort against that person or another person, or the same tort against another person. Battery. Battery is the intentional infliction of a harmful or offensive contact against the body of another. Assault. Assault is the intentional infliction of an apprehension of an imminent harmful or offensive contact. Apprehension requires that the plaintiff be aware of the threat. False imprisonment. False imprisonment is the intentional confinement of a person to a bounded area from which there is no reasonable means of escape, and the person is aware of the confinement or harmed. Trespass to land. Trespass to land is the 1. Intentional. 2. Physical invasion of land of another. Trespass to chattel. Trespass to chattel is the 1. Intentional. 2. Interference with a person's use or possession of a chattel. Conversion. Conversion is the 1. Intentional. 2. Interference with a person's use or possession of property that is so severe that it warrants payment of the full value of the property. Intentional infliction of emotional distress. Intentional infliction of emotional distress is 1. The intentional or reckless. 2. Infliction of severe emotional distress. 3. Caused by the defendant's extreme or outrageous conduct. A third party who witnesses the act, but is not a direct target of the conduct, can still recover if they were present and the target was a relative, or if they were present, known to be present, and suffered physical harm. Defenses. Self-defense. A person is entitled to 1. Use reasonable and proportionate force. 2. When they reasonably believe it is necessary to prevent. 3. Threatened harm. The use of deadly force is only allowed if the defendant is reasonably in danger of death or serious bodily harm. A person may use only the degree of force necessary to prevent the threat and must retreat if possible. Under the castle doctrine, a person is not required to retreat if they are in their own home and defending against an intruder. Defense of others. A person is entitled to 1. Use reasonable force. 2. To prevent harm to others. 3. When they have a reasonable belief that the other person could have used force to defend themselves. Consent. A plaintiff may not seek relief if they consented to the conduct. The conduct must be within the scope of the consent. Necessity. A person may interfere with the use or possession of the property of another if such interference is necessary to prevent a greater harm. If the necessity is to protect the public, no compensation is due. If the necessity is to protect a private interest, the defendant must pay for the damages. Shopkeeper's privilege. A shopkeeper is allowed to temporarily detain a person for a reasonable time if they have a reasonable belief that shoplifting has occurred. Negligence. To establish a prima facie claim of negligence, the plaintiff must show that the defendant's conduct posed an unreasonable risk which resulted in harm. The plaintiff must establish duty, breach of duty, actual causation, proximate causation, and damages. Duty. Duty of care encompasses both 1. The people to whom the duty is owed, and 2. The standard of that duty. In the majority Cardozo view, a duty is only owed to those foreseeable plaintiffs within the zone of injury. In the minority Andrews view, a duty is owed to everyone. Standard of duty. The defendant must act as a reasonably prudent person under the circumstances. Common law landowner duties. Under the common law, The duty of a landowner depends on the relationship with the plaintiff. A trespasser is owed no duty. A known trespasser is owed a duty to warn of serious risks. A licensee is owed a duty of reasonable care and a warning of known dangers. An invitee is owed a duty of reasonable inspection and repair. Negligence per se. Both duty and breach can be established if the defendant violated a safety statute. The plaintiff was in the class of persons the statute was intended to protect, and the harm was of the type that the statute was intended to prevent. No duty to rescue. There is no duty for a person to rescue unless there is a special relationship, or the person caused the danger. However, once a person starts a rescue, they must proceed with reasonable care. Children. Children have a duty to act as a reasonable person of the same age, unless they are engaged in an adult activity, such as driving. Breach. A person has breached their duty if they fail to conform to the standard of care. Res ipsa loquitur. Res ipsa loquitur establishes breach of duty, even if the conduct cannot be identified. If the harm is of the type that does not occur absent negligence and the instrumentality responsible for the harm was under the defendant's control. Actual causation. Actual causation requires that the harm would not have occurred, but for the defendant's conduct. Proximate causation. Proximate causation requires that the harm was a reasonably foreseeable consequence of the defendant's actions. The harm can be unforeseeable if the harm was a result of superseding or intervening events that could not reasonably be foreseen. Thin skull plaintiff. The defendant is liable to all harm to a plaintiff, even if the physical consequences were due to an unforeseen weakness or susceptibility. Damages. The plaintiff must establish actual injury or damage to property. Purely economic harm is not recoverable. Negligent infliction of emotional distress. The defendant is liable if he engages in negligent conduct that causes the plaintiff to suffer severe emotional distress. The plaintiff may recover under a direct or bystander theory. Under a direct theory, the plaintiff is the victim of the negligent conduct. If the plaintiff suffers an impact, the emotional distress is considered a parasitic damage to the physical harm. If there is no physical harm, the emotional distress is the measure of damages as long as the distress is extreme. CA. Or if there is a physical manifestation of distress. Majority. Under a bystander theory, a plaintiff may recover for an impact to a close relative if he observes the danger. CA. Or is in the zone of danger. Majority. Defenses. Contributory negligence. Under the common law, any negligence on the part of the plaintiff that contributed to the harm acts as a complete bar to recovery. Comparative fault. Most jurisdictions have adopted a comparative fault doctrine that limits, but does not completely bar recovery. The degree of limitation depends on the proportion of fault and the jurisdiction's rule. California has adopted a pure comparative fault rule that assigns recovery based on the proportion of the defendant's fault. Assumption of the risk. Plaintiff's recovery may be barred if P voluntarily and knowingly assumed the risk of the defendant's conduct. Strict liability. Strict liability is liability without the need to prove duty and breach. Wild animals. The owner of a wild animal is strictly liable for harm caused by the dangerous propensity of the wild animal. Abnormally dangerous activity. The operator of an abnormally dangerous activity is strictly liable for harm. 1. If there is a high risk of harm. 2. The risk cannot be reduced with due care. 3. The activity is not common or appropriate for the location. And 4. The risk is greater than the value. Strict products liability. A seller of a product is liable without the need to prove duty and breach for any personal harm caused by a defective product. The plaintiff must establish that 1. The defendant was a commercial supplier. 2. There was a defective product. 3. The product was the actual and proximate cause of the harm. And 4. Damages occurred. A defective product can be established by a manufacturing defect, a design defect, or a warning defect. Manufacturing defect. A manufacturing defect occurs when the particular product is more dangerous because of a material deviation in design. Design defect. A design defect can be shown by 1. The consumer expectation test, which requires that the product meet the minimum safety expectations of its ordinary users when used in a reasonably foreseeable manner, including misuse. 2. The risk utility test, which requires that risk inherent in the design outweighs the benefits of the design, or that there was a reasonably feasible alternative design that was less risky. A warning defect exists when the maker fails to provide adequate warnings about known dangers. Actual causation. The harm would not have occurred but for the defective product, and the defect was present when the product left the defendant's control. Damages. Physical injury or property damage must be shown. Like negligence, there is no recovery for purely economic loss. Defenses. Assumption of risk. The purchaser 1. Discovered the defect and 2. Unreasonably and voluntarily used the product despite this. Comparative negligence. Contributory negligence. Plaintiff's negligence is a complete bar to recovery when the plaintiff's fault consisted of unreasonably proceeding in the face of a known product defect. Nuisance. A private nuisance is the substantial, unreasonable interference with the use and enjoyment of one's land. A public nuisance is a substantial, unreasonable interference with the health, morals, welfare, safety, or property rights of the community. Coming to the nuisance. Coming to the nuisance is generally not a defense but may be considered by the jury in determining whether the plaintiff can recover for the nuisance. Defamation. Defamation is 1. A false and defamatory statement. 2. Of or concerning the plaintiff. 3. Published to a third party. 4. Causing damage to the plaintiff's reputation. Libel. Slander. Libel is written or printed defamation. Slander is oral defamation. For libel, damages are presumed. For slander, special damages must be proven unless the defamation was slander per se. Meaning the statement 1. Accuses the plaintiff of a crime. 2. Having a loathsome disease. 3. Being unchaste. Or 4. Unfit for business. Constitutional issues. Public figure. The Constitution protects freedom of expression, especially the critique of elected officials. If the plaintiff is a public figure, under the New York Times standard, the plaintiff must show that the defendant acted with actual malice, meaning that the defendant made the defamatory statement with actual knowledge of its falsity or with reckless disregard for the truth. Damages are presumed. Private figure. Public concern. If the plaintiff is a private figure but the statement is of public concern, the plaintiff must only show that the defendant acted with negligence, and can only recover actual damages, unless actual malice is shown. Damages may be presumed, and punitive damages may be awarded. Defenses. Truth of the statement and consent to make the statement are complete defenses to defamation. Absolute privilege. Absolute privilege protects remarks made during judicial or legislative proceedings by government officials. Qualified privilege protects statements made to protect 1. The defendant's interests. 2. The interests of the recipient of the statement. or 3. The public in general. Privacy. Misappropriation. Misappropriation is the unauthorized use of the plaintiff's name, image, or likeness for the defendant's commercial gain. Intrusion on seclusion. Intrusion on seclusion occurs when the defendant intentionally intrudes into plaintiff's private affairs in a way highly offensive to a reasonable person. False light. False light arises when the defendant 1. Widely disseminates 2. False or misleading information about the plaintiff 3. To the public 4. In a manner highly offensive to a reasonable person. Public disclosure of private facts. A defendant is liable when 1. He publicly discloses 2. Private information about the plaintiff which are not of public concern, and 3. The disclosure is highly offensive to a reasonable person. Misuses of legal process. Malicious prosecution. A defendant is liable for malicious prosecution if he is actively involved in wrongly bringing about criminal or civil proceedings against the defendant without probable cause or for an improper motive. Prosecutors are immune from liability. Abuse of process. Abuse of process is the intentional misuse of legal procedures for an ulterior motive, done willfully in a wrongful manner that results in harm to the plaintiff. Tortious interference with a business opportunity. A defendant is liable if he intentionally interferes with a valid contractual or business expectancy of the plaintiff, knowing about the right. The defendant can defend on the grounds of proper competition. Third-party issues. Vicarious liability. Vicarious liability is when a third party is held responsible for the tortious act of another based on a special relationship between the tortfeasor and the third party. Respondite superior. An employer is liable for the tortious acts of his employee if the employee commits a tort while working in the course and scope of employment, but not for tortious acts of an independent contractor. Actions are within the scope of the relationship. 1. If the conduct was of the kind the agent was hired to perform. 2. The tort occurred while so acting. And 3. The agent intended action to benefit the principal. Independent contractor exceptions. An employer, while not vicariously liable for the acts of an independent contractor, may be liable for 1. Negligence in the hiring of an employee, or 2. If the duty is non-delegable because it involves work in a public place, or 3. An inherently dangerous activity. Joint and several liability. When two or more negligent defendants combine to proximately cause an indivisible harm, each tortfeasor is liable for the entire harm. The plaintiff can recover the entire damages from one defendant, and that defendant is eligible for contribution from the other joint tortfeasor. Indemnity. Indemnity occurs when one party takes responsibility for the entire loss. To indemnify means that one party accepts responsibility for tortious acts committed by another.